Hello, everybody. Welcome to Chatting with Charlie, EB5 Investor Outlook for March of 2025. My name is Joey Barnett. I am a partner at WR Immigration. I practice in EB5. I've been doing it for the past 15 years, and I am so happy that you guys are joining in to listen to us. We are live today. I feel like I say this every month, there's been a lot that's going on in the world of EB5. And for people who are just learning about EB5, whether it's someone who is thinking about doing an investment or somebody who watched The Daily Show and saw the gold card being mocked, this is a place where we are providing facts. And I have a couple of opinions, I guess, of my own that I will be sharing. I'll be giving my take on it. But of course, the real reason why you guys are all here, it's not to listen to me, it's to listen to Charlie Oppenheim. And Charlie is a former member of the Department of State, and he wrote the Visa Bulletin for over 2 decades. The Visa Bulletin is the document that the Department of State puts together every month that indicates visa availability. And that controls when individuals are able to get their green cards. And so it is always an honor and a pleasure to be speaking with you, Charlie.
It's my pleasure to be able to speak to the group.
We do have a chatting function, so please feel free to do that. We also got a number of questions from people who registered, so thank you so much. I do see a lot of existing clients and other folks in the EB5 industry, so thank you guys so much for listening in. And for people who are, again, brand new to EB5, we're going to be talking about what that program is as well and how it's different from what President Trump talked about in the Oval Office the other day. Again, my name is Joey Barnett, and we are talking all things EB5 today with Chatting with Charlie. I've been doing EB5 for about 15 years. Our firm has filed over 6,000 EB5 petitions. We're consistently ranked as one of the top EB5 law firms in the country, and we are very, very happy to help. So please reach out if you have questions. My email is jbarnett@wolfstorf.com, and I'd be happy to talk to you. We also have our Visa Law at wolfstorf.com. And this does not constitute legal advice. It's just for information purposes, but we'd be pleased to talk with you. So come on and schedule a consultation. And WR Immigration, if you don't know by now, we are a immigration law firm based in the United States, though we have offices globally, and we are one of the top firms in EB5, like I mentioned, but not just EB5, we do all things immigration based, and we're seeing a lot of I-9 compliance issues that are coming up, a lot more restrictions with regards to employment-based adjudications. So if you have questions on that, we have attorneys who are able to assist. All right, finally, the roadmap for today. We're going to be talking about Mr. Trump's gold card. We're going to be talking about the March 2025 Visa Bulletin, Charlie's takeaways from that. And then we're just going to be getting into some statistics that we have and have seen over the past couple months and what that may mean. And the big thing that I want to talk about is that there still is this opportunity for folks who are in the United States while the Visa Bulletin is current to file an adjustment of status concurrently with an EB5 petition. And so let me translate that into English. Pretty much, it means that when you file your EB5 case, you also get to file for a green card at the same time because there's a visa available according to the Visa Bulletin. And with that, gives you the opportunity to get an EAD, which has unrestricted work authorization, and advanced parole, which allows you to travel during the time in which your adjustment of status is pending. And so that adjustment of status will be pending until a visa is available. If a visa is not available because a backlog occurs, then you can indefinitely extend that EAD and advanced parole because your adjustment remains pending. At least that's the law as it is today, and we'll see if changes come along the way. And one of the big changes that we're seeing, of course, is Mr. Trump and his Department of Commerce Secretary Lutnick talking about the gold card. Okay, so what is this? What they have indicated, and it's very limited, and it is just some guys talking around a desk. There has been no executive action. There has been no congressional changes to anything. It's just, I believe, a bargaining position. But what he's pretty much saying is, let's get rid of the job requirement from EB-5 and increase the investment amount, and you get your lawful permanent residency that way. I mean, I guess you also get privileges plus. I don't know. We'll see. We'll see. $5 million is the price that he put on a gold card. And, people have different points of view on whether there's demand for this. Are there going to be tax considerations built into this? The Department of Commerce did indicate that they're going to be working with DHS and with the Department of Treasury to put this program together. And so when I hear those words, I hear it as something very separate from EB-5. And then I hear that they're going to be trying to do this through reconciliation process, which is a congressional way of getting laws passed without needing to have more than just a minor majority, which is very important during the time in which our country is so partisan. And from what I understand, this is going to be offsetting, extended tax breaks and other things that they're trying to do to make this budget work. I am not a fan of Congress. I don't think they do their job well. It remains to be seen what will happen. And you need an immigration attorney who's on top of it and who's going to be advising you. But, until then, the law for EB-5 is in the books. 8 USC 1153 B5 is still there. You can't take a Sharpie to the Immigration and Nationality Act because you don't like it. And if USCIS stops adjudicating cases or slows down cases, well, then what you need to do is you need to enforce your rights in the judicial branch, right? Congress creates the laws, the executive helps enforce them. And if they're not doing their job and what they're supposed to be doing, then you can turn to the federal judiciary and say, look, these guys have a duty to adjudicate. And I think that's what's going to end up happening here. Overall, my thoughts is that this is all kind of a big play to show the value of what it means to be a green card holder. And by that, I am saying he is trying to restrict certain types of immigration, and he's trying to promote other types of immigration, which is very different than the current agenda that is in the Immigration and Nationality Act. And it seems like a lot of Americans agree with a lot of the policies that he has to say. And so he's moving forward with it. And, residency by investment is something that kind of EB-5 has always shied away from. It's something that we've always said, no, 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 no. It's a job creation program. And so we're going to start seeing potentially this is a good place for the EB-5 industry to say, well, look, there's a benefit here for job creation for US workers, and maybe something come 2027 when the regional center program is expired, maybe we can get some, sort of deal done there. And that's certainly the goal. My thought and goal is that if this is being done through the Department of Commerce, maybe this doesn't impact EB-5. It's really too tough to tell. Charlie, can I get your thoughts on this? I mean, do you think a president has authority to create a new employment-based immigration category? I mean, I know it's sort of silly, but give me your thoughts on this.
No, in the 43 years I worked for the State Department, in the 23 years I was chief of immigrant visa control, only Congress had the ability to change the immigration law. And historically, Congress has never acted in a very expeditious manner. The last major overall change in the Immigration Act occurred with the Immigration Act of 1990. And those changes did not take effect until fiscal 1992. So again, there was a delay in the changes that were passed in 1990. Some of the things that were mentioned, I heard a soundbite where he said that maybe 2 million of these gold cards would be given out. That would be roughly 5 times the normal immigration annual limit. Right now, family and employment, the minimum limits total 366,000 a year, and he's proposing potentially giving 2 million of these gold cards. Also heard that the EB-5 program had not been a benefit. That seemed outlandish to me to say, especially somebody from Commerce coming through and saying that. My guess is in the last 10 years alone, the EB-5 program has generated in excess of $15 billion of investment into the US economy. Those investments have created over 300,000 direct new US jobs. And I would say that millions of indirect jobs have been created. So again, I was very disappointed in the Commerce Secretary's comments regarding how the EB-5 program was not beneficial to the U.S. I would go as far to say that in the early years of the EB-5 program, it may have saved many of the U.S. investment real estate programs, et cetera, by infusing the cash into support programs when funding was not available to the real estate developers through their normal U.S. contacts. The influx of money from outside the U.S. basically saved them after the downturn of 2008.
That's a really good point. That is when EB-5 kind of blew up. It was during that Great Recession when financing was a little bit tighter and it was harder for real estate developers to get funds. And that's why they started turning towards EB-5. And I'm really glad you mentioned that, Charlie, because the commerce guy was saying, there's all this fraud in EB-5. Well, the Government Accountability Office did a report in 2023, and they said that less than 1% of EB-5 petitions involve fraud. So that is
Right.
just factually untrue, and it spreads obviously bad rumors about EB-5, and they have their agenda. But, the facts say something else. And I'll say this, as someone who's been practicing in EB-5 for so long, is that it has been a pathway for many individuals to the United States for their children when there frankly was no other option because of the limited availability in certain other employment-based categories or just the lack of options in general to qualify to come to the United States. People think of the United States as, give me your poor, you're tired, very welcoming to immigrants, at least historically. I think that's sort of how the United States has been viewed and, the Statue of Liberty, everything like that. And, the fact of the matter is that the laws make it difficult and you have to either have certain family relationships or employment or skills, or in the EB-5 case, you need to invest lawfully obtained money and create jobs for U.S. workers. That's the law that Congress passed. It's still on the books. And I am going to continue filing cases for my clients full speed ahead because let's just say I'm trying to think about the end game here. All right. So this was in the EB-5 Reform and Integrity Act of 2022. There is language in here, thankfully, that says if the regional center program is expired, meaning not extended by September 2027, then DHS is still supposed to adjudicate I-526s and I-829s, and they're not allowed to deny cases based on the expiration of the regional center program. And then this last one as well is really important. They're not allowed to suspend or terminate the allocation of visas to beneficiaries of approved petitions, meaning that they are to continue processing these until you get the final green card, the permanent green card. Do you agree with my assessment that that's what this language says, Charlie?
Yes, I do wholeheartedly.
Good. Now, something we've talked about before, who allocates visas? Isn't that something the Department of State does, not the Department of
Yes,
Homeland Security?
correct. The Department of State is responsible for the numerical control process. They do so in consultation with USCIS, getting information from USCIS, primarily on the employment categories, which is our topic today. But it is a joint effort. And the Immigration and Nationality Act does specify that the Secretary of State is responsible for making these decisions. I acted in that capacity for over 23 years, determining how many numbers were available on an annual basis based on previous year's data, how to allocate numbers on a per country basis, etc. And again, that was done in consultation with my counterparts at USCIS. I think that sometimes people just kind of forget about the State Department in this, and it's easier for them to refer to it as DHS handles it.
Right. Well, it's just one thing that I am focusing my attention on because I have clients who are doing EB-5 and they're nervous that their petitions are going to be stalled or going to be denied or that they're just going to get rid of this in the next 2 weeks. And we have questions here in the forum, Mr. President are clearly saying that EB-5 will be replaced with the gold card and current program will be scrapped. I don't see where they're saying that. And they say the start sale is in 2 weeks. I don't see where they're saying that. He's saying that he hopes to see something in 2 weeks, and that would probably mean some regulations need to get passed, or maybe a law needs to get passed, and then regulations need to get passed, and then maybe forms need to get created. And again, they can't do this without Congress to help. So if you think Congress can do anything in 2 weeks, I have some really good oceanside real estate for you in Nebraska I would like to sell.
One other
But
thing, Joey, on this little I where it talks about the termination in 2026, people may remember that there was a pilot program previously that was extended at 3-year increments. That was done from 95 through 2014. It wasn't until 2015 that Congress got into this kind of game where they tied up EB-5s in the annual appropriations bill. But again, the original program was, a pilot program for the I-5 and R-5 categories. And they were 3-year pilot programs. And over 20 years, they were automatically extended at the expiration time. So I'm not extremely concerned about this. Again, I mean, how would it be possible to establish and get a very complex operation such as this would be required up and running in 2 weeks' time? I mean,
yeah,
it just
don't see it
doesn't make sense.
happening. I mean,
It's great for a scare tactic or just off the cuff comments, but it's not realistic, especially when you're talking about efficiency in government, creating a massive program in 2 weeks.
I got a question here. Does the termination or expiration protection language of the RIA also apply to pre-RIA investors? That's definitely how I am interpreting this, and I think that was the point of putting the language in the first place. It would be silly to me for it to only apply for post-RIA investors, but that's a great question. Can the president revoke congressionally approved RIA EB-5 with an executive order? No. The answer is no. He is not a king. He doesn't get to do that. And if he were to do something like that, you can bet your bottom dollar that there would be a lawsuit challenging it. All right. Will the recent gold card potentially lead to indefinite delays with USCIS processing? Okay, this is a good question too, because the executive branch does control DHS. It does control the resources. It gets to allocate it pretty much as it pleases, as long as it complies. But there's a lot of wiggle room in there. And yeah, I do think there could be some delays that relate to EB-5 processing if this were to move forward, if they have to move, officers that have training in EB-5 on source of funds to go to the Department of Commerce because they need to get their folks trained in order to adjudicate those applications. Yeah, maybe. It remains to be seen. But I guess the main point that I'm trying to tell people who are thinking about doing this is that there's always been risks with EB-5. And, there's the investment risk and then there's the immigration risk. This obviously all relates to the immigration risk. Is the point of doing this, investing all this money, worthwhile? And that is the other thing I wanted to mention. It seems that a big difference between the gold card and EB-5 is that this is an investment program where if you pick a project, you're able to get your money back. The way that he is describing it, the way I'm understanding it is this is like a payment to the national debt and a way to balance the budget. That's what they're talking about in these cabinet meetings is, deficits and debt and, using, I guess, foreign investment to balance the budget. Okay, I'm just trying to get through these questions before we move on from the gold card. I don't think it was mentioned that the 5 million price tag was for a family or for an investor, but I love that this point is being made. And I think it's something that EB-5 needs to jump on and push to say, yeah, EB-5 is meant for 10,000 investors, not 3,000 and their derivative beneficiaries. So I think this is an opening that we certainly can use to our benefit there. Okay. So the president cannot legally terminate EB5. Correct. But the existing investors, is there a chance that he could play dirty and throttle DHS resources working on adjudications? Yes. Not going to lie. But there's also legal rights that you have if there are delays or if there are denials that are arbitrary and capricious. That's what the Administrative and Procedures Act is. Oh, here we go. This is a good question. Thank you, Calvin. Does the president or executive office have the ability to reallocate available visas from EB5 to gold card applicants? That's a question for Charlie. That's a good one.
No, the Immigration and Nationality Act specifically says where the employment category visas go. So it designates that if there were any unused employment fifth preference numbers, they would fall, quote, up to the employment first preference. But you cannot arbitrarily move visa numbers around. That historically has always required some type of congressional action. So again, it's not realistic at this point.
Well, my thought is, I guess my closing thought on this before we get into the Visa Bulletin and the opportunity that exists, because this is a risk and something that everybody is now thinking about, obviously. And, I'll say it here. I've said it again. I feel like I'm wrong every time there's some sort of law or policy related to EB5. I was wrong about the regs in 2019. I was wrong about the litigation stopping the regs in 2021. I was wrong about the expiration and then reauthorization of the program and when that was going to happen. So I don't know what's going to happen. All I know is that this opportunity is available now. You can file for your EAD and advanced parole now. We're still getting them, sometimes in as quick as 5 to 6 months. And if you're stuck in a backlog, you at least have the ability to live here in the event there's layoffs and you aren't able to find an H-1B transfer within 60 days. You don't have to leave the country because you have a pending adjustment. Now, you can't work until you have a valid EAD, but it gives you a backup plan or a backup plan in the event that something were to happen with your H-1B sponsor. I advise people maintain your non-immigrant visa status because it gives you the most amount of options in the event something were to happen with EB5, or at least till the I-526E is approved. But if something were to come along and there's a great business opportunity, you have that EAD, okay, you can go use it. You can go do that. And now you're using that EAD to work for your H-1B employer, and you're using your EAD to work on your own business. It gives a lot more flexibility to people. And the reason why you can do that is because of these C's in the Visa Bulletin. And so that's, again, Charlie wrote this thing for over 2 decades. And so, Charlie, maybe can you just give us a little bit of a breakdown of what we're looking at here and, I guess the different types of EB5 categories that exist?
The top line, the EB5 unreserved, that's the pre-RIA applicants that filed. And when you see for China and India a date listed, that is the priority date of the first applicant who could not be accommodated for final action on their visa case in the current month of the Visa Bulletin. So again, for China, only applicants with a priority date earlier than July 15th of 2016 are eligible to be processed in the pre-RIA fifth unreserved category during the month of February. It's going to be the same for March. It's going to be the same, I would guess, for the foreseeable future. In those categories, the State Department knows that there are a significant amount of Chinese and Indian applicants, so they can hold these dates, the July and the January dates. They could hold those dates in place until the summer months and then move them if they need to and still fully utilize the maximum amount of numbers available under the unreserved category. For the set-aside categories, the rural, high unemployment, and infrastructure, it is completely C's. The C's mean that it is current. There are numbers immediately available for use by any applicant with an approved petition. Again, as Joey said, this allows you to file concurrently, which is a very unique process to this program. It's something that has not been available in the past, and I would urge you to avail yourself of this opportunity.
So you could still file an EB5 petition after the C is gone and there is a final action date. It just doesn't give you the ability to file an adjustment of status concurrently, right?
Correct. Yes, this is to Chart A, and effective February 1st, the USCIS said for filing for adjustment of status, this chart governs such filing. There is also a Chart B, and that represents where the final action dates in Chart A are likely to be in 8 to 12 months from when these dates were established. And if USCIS indicates that these dates can be used, which they did through January. So a Chinese or Indian applicant with a priority date earlier than one of these through January could have filed for adjustment of status based on these dates. But again, the fact that they've switched to Chart A on the set-asides, it still remains current. So you are in amazing shape in terms of filing concurrently for the foreseeable future.
At least in the next few months. I mean, in the way that it works, and for people who are in EB5 that they know this, but for people who don't, the way that it works is the Department of State makes their projections about visa availability based on approved cases by USCIS, not pending cases at USCIS. And because of that, and because USCIS has not approved enough of these I-526Es, there hasn't been enough demand that is visible to the Department of State to say, okay, actually, we do need to put some limits on. Am I saying that correctly, Charlie?
Yes, they use the Chart B to generate new filings to use numbers down the road. But if you go back to Chart A, the Chart A final action dates, a final action date would only be applied when, for example, the State Department early next week will start determining the April final action dates. They will look at the number use through February, and then they will take that total, and then they will estimate how many numbers they believe will be used in March and April based on the new dates, and subtract that from the overall annual limit. They would only impose a final action date if they determine that future number use will exceed the annual limit. Right now, based on the best information available, unfortunately, transparency by USCIS and state has not been great, but there is no reason to believe there's enough approved petitions to require any final action dates in the foreseeable future.
And so, again, I'm saying caveats on this because I don't want it to be misinterpreted and because it's complex and hard to understand. Just because it is current today and you get to file the adjustment of status today does not mean that when your I-526E is approved in 12, 14, 16 months from now, that there won't be a backlog then. And if your priority date is after the final action date, then you aren't able to get your adjustment of status approved. In the meantime, you have your EAD and your advanced parole, and you are somewhat sitting in that backlog the same way that you're somewhat sitting in an EB2 or an EB3 backlog. Now, Charlie, is there anything stopping someone who's in an EB2 or EB3 backlog from doing EB5?
No, in fact, if somebody has the means, if they're in an EB2 or EB3 and they have the means to do so, they could invest in the EB5 program and get their priority date established. Then they would be having two chances at a visa each month, and they could utilize whichever came first. And I'm glad you brought up the point that the date which is listed in the Visa Bulletin in the month your case can be eligible for final action governs whether your case can be acted on. So it's not what the final action date was when you filed, it's what the final action date is when your case is ready for actual adjustment of status or visa issuance overseas.
This was in the January Visa Bulletin, and I think what they're saying here is that we're seeing increasing numbers of applications, more filings coming in the set aside categories. And I think this is kind of like a warning shot saying, look, there is going to be a final action date at some point during the fiscal year so that they don't exceed the annual limits.
Yeah, this is the type of thing I always tried to put this type of notice in the Visa Bulletin at least 1 to 2 months before I saw any action was likely, so people could, like you said, have a warning shot. I believe that state did this strictly because they saw the amount of petitions which have been filed will eventually exceed the amount of numbers available. I do not believe that they were seeing the amount of approvals jeopardizing that at the time they made this announcement. So I would watch the Visa Bulletin for items such as this in the coming months. Again, I believe that when they believe that it will be necessary to establish a final action date and list it in Chart A, I think that they will give another one of these type of warnings 1 to 2 months in advance. But again, so watch. I do not know that the amount of numbers being used so far would warrant the establishment of a final action date. Again, final action date should only be imposed when a combination of past and reasonably estimated future use will exceed the annual limits. And right now, we have no data available to us that would indicate that will happen in the coming months.
Thank you, Charlie. I think that's really helpful for everyone to hear. And so, would you suspect that the Visa Bulletin would say in a footnote that we're going to see a final action date coming again, or do you think this is it?
I would expect them to maybe in the summer, maybe as early as May or June, indicate something. But I do not believe, again, here it lists how many, there be almost 1,500 approved rural petitions be required to utilize the rural limit for this year. Are there that many approved petitions already, or will they be? The State Department provides number use totals. The latest they have is the data from October through December. I believe there were approximately 21 rural visas issued overseas. Immigration Service doesn't publish any data, but again, it would be necessary for the approval rates to increase dramatically and number use to also increase dramatically in the next several months. It's also important to remember that anybody processing overseas is going through the National Visa Center, and only once their case becomes documentarily complete, they've submitted all required documentation. From that point, it still takes at least 2 months before they would be scheduled for interview and use a number. Again, kind of kicking the can down the road in terms of when a final action date is likely to be imposed. So I think that things are going to be safe through early summer and possibly through the entire fiscal year on rural and infrastructure remaining current. I think that the potentially high unemployment areas would be the first to see a final action date imposed. And I'm not sure that's going to happen in fiscal 2025 either.
Got it. And so this gets to a question that we got before. It says, when would the concurrent filing quota be exhausted? What happens when it happens? I don't know if that's the right way to phrase it, but once there is a final action date imposed in the Visa Bulletin, that restricts the ability of someone who's in the United States today to file a concurrent adjustment of status because there is not a visa available at that time. And that's the opportunity. We know that there is a backlog coming. You have to know this. It's right there on the horizon. We all see it. Okay. I don't want, like, this happened in the EB-5 industry 10 years ago, and there are huge backlogs in China because of it. And I'm trying to spread awareness on this for people who are in the United States. They need to know there's going to be a wait time. This isn't going to be a 1 to 2 year process. It's just not. And for people who are filing today, I hate saying it, you're kind of late. You're late to the party. And there are already people who have been at the party before you, and they're getting their green card before you. And there's a limited number of green cards that they can hand out, and you're going to have to wait your turn. But in the interim, get your adjustment of status in, get your EAD, advanced parole, and get your spot a second chance of being a green card holder. That's what I'm telling people.
Real quick, Joey, the fact that I say it'll be current, that I expect to be current, like you said, this year, there will definitely be final action dates in fiscal 2026.
Yeah, that was going to be my next point, is that there isn't going to be a backlog necessarily until at least the summer months, on the fact that there's a huge supply and not as much demand. But come 12 months from now, there's going to be less supply because there's less rollover visas, and there's going to be presumably more demand because USCIS will be processing and approving cases. So that's the change between now and what we may be seeing in October when the new fiscal year starts.
Yes. Yeah. There is no reason to believe that there will not be enough approved petitions between now and the end of the fiscal year
To account for the lower limit in fiscal year 26.
in fiscal 2026. So, although the approval rates are low now, they're going to continue to have more months. So as by the time we hit in October at the beginning of fiscal 2026, the amount of approved petitions should be beginning to be sufficient to require a final action date. And most likely, I would tell people to start watching for something listed in Chart B as early as May. That would be the first indication that a final action date would be imposed, is when state announces an application filing date, because they're going to want to start limiting filings that would account for number use in the next fiscal year.
All right. Well, you heard it here first, folks, and get ready and take advantage while you can. All right. A couple of immigration questions that we have here about using an EAD that I just want to answer before we move forward. Okay, so for the first one, for current H-1B holders, if we were to use the EAD, what happens to the H-1B? Is it paused? No, you are no longer maintaining your H-1B status when you work for somebody other than your H-1B sponsor. You can do that once you have a valid EAD and you're not going to get in trouble, but you are no longer maintaining your H, and you are then in the United States with a pending adjustment status or in a period of stay authorized by the Attorney General, because you filed your adjustment while you were in lawful non-immigrant status. Wow, that was a mouthful. I hope that made sense. Did that make sense to you, Charlie?
Yes.
Okay, fair enough. All right. So is it paused? No, it's not paused. Is there a way to use it again if you were to find an H-1B sponsor, or do we lose it since we're still in the United States? The way that I have always understood it is that, let's just say something were to go wrong with your I-526, it's denied and you can't get the green card through EB-5, and now you want to go back onto H. The way that I understand it is, if you use your EAD, then you need to do that through consular processing, not in the United States. But if you're stuck in a backlog, and this gets to another question, what are EADs renewable if the end-to-end getting your green card process takes longer than 5 years? Well, only until your conditional green card status. Once you have the conditional green card status, then the EAD and advanced parole no longer matter. You use the conditional green card to work, travel, live, and do what you want in the United States. Until then, you can extend the EADs because your adjustment is pending. What's the max renewal length? Is there a period of time when you're in adjustment status, you're allowed to stay, but you're not allowed to work? No, you can always be continuously extending your EAD. I guess there could be a period of time where you have a pending renewal and your one is no longer valid, and then you're kind of waiting. I think there's a 540-day automatic extension involved there. I think that could be reduced if the Trump administration wants to. So for someone filing this week, what's the current estimate for a conditional green card? That's tough to say. It depends on your country of birth. It depends on what visa category you go to. And honestly, it depends on how many rest of world visa applicants used reserved visa numbers. And what we're seeing in the Department of State is that after your reserved I-526 is approved, you are getting the choice to go through the second part of the process in the unreserved category. And the more people that do that, the more visas will be available for China and for India. And that will open up sort of the door wider for more cases to go in. We don't know the answers on that one. All right. I think I got all those questions. Let's move to the next slide. And thank you for asking. It's more fun when it's engaging like this. All right. This is the limits that we were talking about before for fiscal year 2025. There's actually a fair number of BB5 visa numbers this year, and the orange slides relate to what DOS put out. The blue relate to the carryover that is from the unused reserve visa numbers accordance to the RIA. So this just shows the supply that we have. And that set aside the 7,166, well, 62.5% of those go to rural. Half of that amount goes to high unemployment, and 1/10 of that amount goes to infrastructure.
And it's important to remind people that new to DB5, this carryover provision is unique to the RIA cases. There is no carryover of unused numbers in any other family-sponsored or employment-based categories. So this is the unique opportunity. So any numbers that weren't used in fiscal 2024 will fall and carry over to 25. Any unused 25 numbers would carry over for 1 year and would carry over to 2026. The unfortunate side of the carryover is this is contributing to any future waiting list because thousands of numbers have gone unused in the earlier years, fiscal 22, 23, where cases, if they had been acted upon in a timely manner in the approval of petitions, numbers could have been used and applicants could have been processed, limiting the quote negative effect in future RIA cases. There were tens of thousands of numbers which were quote wasted because of the slow processing of petitions when numbers were available and led to lengthy backlogs.
Right. And I think we have to give the government a little bit of room to get a case going and then process the cases and things like that. But this is why we're keeping such a close eye on, well, are the consulates actually scheduling visa interviews for these people? And thankfully they are. We're starting to see it. And that's great news because in the first few months of the fiscal year, it just wasn't happening.
And to your point, I believe the state, at least for the overseas cases, I think that the State Department is front loading their processing of the unreserved cases based on what I'm seeing in number use. I'm hoping they're doing this so that they can have more spaces available for the processing of reserved cases when they start to be received in the second half of the fiscal year.
Okay, so this graph, I'll be frank, I stole from Suzanne. Suzanne, thank you so much for putting your hard work together. If you're an EB5 and not reading Suzanne's blog, Suzanne Lazicki, Lucid blog, EB5, type it into Google. It'll be the first thing that comes up. If you're not reading it, you're doing a disservice to yourself. Suzanne, we appreciate everything that you do and all of the data that you are able to collect and analyze. And Charlie, we kind of just said it, but what do these numbers say to you? In particular, that last column.
Right. They've used 4,500 numbers in the unreserved category. That's pretty good. That's almost 50%. It's 40% of the numbers available. You drop down and you see the rural set aside, 21 numbers, not even 0.5%, 24 numbers in the high unemployment, 1%. So again, these are somewhat depressing, but again, I'm hoping that the State Department has front loaded the processing of unreserved, which they already have those cases to be processed. And therefore, the overseas posts, primarily for Guangzhou, for the Chinese cases, they will have the resources to process reserved cases once they begin to be received in the second half of the fiscal year. When Suzanne gets this data, say in May or June or July, I'm very hopeful that we will see a dramatic increase in the number use because any number use this year will reduce the wait time for applicants in the future.
Right. And this again is just consular processing. So there is an extra step of the case being transferred from the Department of Homeland Security to the Department of State and getting the consulate scheduled. There also are conditional green cards that are being issued via adjustment of status for those inside the United States. And those numbers are much bigger than the 21 and the 24 that we see. Well, I don't know, much bigger. We don't have the data, but I know it's more than these, but still not enough. And I just thought this graph was a really well done way to describe the current situation, or at least as through the end of last year, as to why we need to see more visas being issued.
Yeah. And as you mentioned, Suzanne's done a great job with this. State Department luckily publishes data. It would be so beneficial if USCIS would publish the equivalent data, providing much more transparency in terms of the number use. Actually, the State Department could publish the total number use, but they only publish so far overseas number use during the course of the fiscal year.
Okay, so that kind of comes to the end of our webinar. Charlie, thank you so much for your expertise and insight, and I hope you do well, and I'll see you next month.
Take care.